Grower confusion rises over a court ruling banning the application of 3 major dicamba products. It's a frustrating move for farmers who made planting decisions and purchases based on having access to those herbicides, their tools in the toolbox. Roger McEowen with the Washburn University School of Law joins us now for a further look at Dicamba registrations. Thanks for joining us, Roger. Let's start with an overview of the uniqueness of this product.
Well, good to be with you, Christina. Dicamba is very unique. It's a very volatile chemical. It's rarely sprayed, however, in the summer months. That's because when the temperature reaches about 90 degrees, which it is today in Kansas, dicamba will vaporize, and it's going to be carried by the wind for potentially several miles with that high heat, and that can occur even days after application. And so when the winds are strong, you're going to get spray drift, and if you have a temperature inversion where the temperature is not decreasing with atmospheric height, if that exists or there's been a misapplication of the chemical, those are the particular situations that are going to lead you to spray drift. So it's kind of that deadly combination of heat and wind and temperature inversion and misapplication, which can create the problems. And it can be pretty serious stuff for plants that aren't tolerant to dicamba.
Yeah, you know, it's this off-label use that keeps coming up because if one producer isn't using it correctly, then many producers can be put to blame here, which we have seen in different situations. Talk about the confusion that this causes for growers and what you're hearing from the community.
Well, the confusion, I presume you're talking about the confusion concerning the court case. There's confusion about the dicamba label. Some have said you need to have a couple PhDs to be able to apply that stuff because the label directions are difficult, they are lengthy, and it's just a tough chemical to follow those label directions. Now, the new versions of it are a bit easier to apply, and they have a less ability to drift. So things are getting better with respect to that. And we may have actually peaked in our usage of dicamba nationwide. The other confusion is out there is concerning the court opinion. You had a Ninth Circuit opinion last week that vacated the 3 registrations that exist for the dicamba products, the Extendamax, the Ingenia, and the
Hexapan.
Hexapan, however you say that. That's right. And so does that apply nationwide or not? Now, the U.S. Department of Justice's position on these nationwide injunctions that district courts have been issuing, we've seen that in ag with respect to Lotus. The DOJ's position is you can't do that at the district court level. Now, the circuit courts have the ability to issue what's known as a vacatur in this situation, which under the Administrative Procedures Act, it's not really clear whether that applies nationwide or not. I argue in my article I posted Saturday that should not apply on a nationwide basis, and that actually EPA should take the position that they will obey it inside the Ninth Circuit, which would really mean that this decision would only apply to Arizona, and it wouldn't apply in the major soybean and cotton growing regions of the country. And that would be a relief since the opinion came right in the middle of the growing season, and some are starting to plant soybeans. And so it's particularly bad timing by the court. But that's the position that I would take. I think State Department of Ag should get what's known as a 24C determination, and that's under FIFRA, and then go ahead and allow spraying until EPA sends a letter to the state saying no further use, and that may actually get us through the growing season by the time there's a reaction to that.
washburnlaw.edu/WALTR. I always find such value in reading your thoughts, Roger. I'm sure everybody else will as well. Roger McEowen with the Washburn University School of Law. Thank you for joining us.